The Delhi High Court is in the process of hearing multiple petitions that have challenged the Agnipath scheme created by the Government of India for recruitment to the three defense forces. The government in its affidavit before the court has defended the scheme and has said that it will ensure that the fighting forces of the country remain young and fit, and that the training modules have been changed accordingly, and there is nothing wrong with the scheme. The petitioners, however, have pointed out multiple issues that have been raised with regard to the scheme itself. We're speaking to Advocate Kumud Lata, who is representing some of the petitioners in the matter. Ma'am, now today, once again, the hearing has been adjourned. The hearing will now be on the 18th of November. But what exactly are the matters, that the issues that have been pointed out by your petitions, by your clients in this case?
There are two sets of petition. One is the challenge to the Agnipath scheme. Now the government is saying that it's going to be a young brigade. And the example of the countries that has been given, we know the military bases. Let us take, for example, Russia. The war has been going on. People are leaving the military, those who are there in the recruit. Now, that is one aspect. So, therefore, I have requested the court that you bifurcate the matters into two sets. One is the challenge to the policy decision. Now, the second set of petition is on individual appointment. In Air Force, it is called enrollment. So, they have completed the entire procedure, and no decision was taken by the government that airman recruitment has been cancelled. So they kept on saying that it is delayed because of administrative decision till 31st of May 2022. Now, post filing the petition for the first time in the counter affidavit, the government is saying that no right accrues, but it doesn't still say that it is cancelled or it is applied retrospective.
Now, ma'am, one question that the bench has also asked, this matter was heard before the bench headed by the Chief Justice of the Delhi High Court, and the bench has also asked this question, that even if the recruitment process had begun, what right really accrues to these persons who have tried for enrollment? What does that mean exactly for your clients, for the people of the for the young men and women who are trying to get enrolled?
The right, it says that any person in the country does not have a vested right of appointment. Now, that issue only arises if the government had either cancelled it, but in the case of airmen, which is what I pointed out, this is for intake 121, which was later on converted to 221 because the whole recruitment process was after June. Now the question arises that in our case, the delay was because there is COVID, but in between 5 sets of appointment and recruitment have taken place by way of rally recruitment 3 times, and also by way of conducting an exam and straight away enrolling them. So that is a discrimination. Any administrative decision which is discriminative can be challenged in the court of law.
Thank you very much for speaking to us, ma'am. So this was Advocate Kumud Lata, who's representing several of the petitioners in the Agnipath case. The issue raised by the petitioners effectively is that there seems to be no clarity in the policy itself of what happens to those who have qualified the exams earlier, what is their status, and how exactly does this policy affect the persons who have been waiting for appointments during the COVID period. The hearing now is on the 18th of November, and the Delhi High Court will take a note of all of these issues, all of these aspects, and what the government has said about all of it. In New Delhi, this is Aneesha Mathur for India Today.